Hi, I'm Joanna Toch. I'm CEO of Family Law Cafe, and I'm doing a Tea Time Live today. And what we're going to look into is whether you can get costs in a children case. And we're going to look at all of that. Really interesting subject, I think, because there's so much to it. And maybe just me that's interested. Feel free to look away. I'll switch off now if it is not your thing. But costs in children cases, that's what we're going to be talking about. It's a live, so if you want to make a comment, just give me some comments down below. I can have a look. If you want to tell me where you're joining from, always interesting in the comments. And if you think there's something that is interesting, just put a comment there and I might just talk more about it. I think that's the whole point of a live, isn't it? That I'm unscripted. I always have a check over the law before I start, just in case, something's changed since I was last in court. But I'm trying to give you the important parts, because of course we can all go and look at and look up what's in the rules and regulations, what's in the law, and we can look at that, but we might not know how that practically applies. And of course, people don't get the chance to generally sit in on a children case because, of course, it's private, isn't it? And so there's that balancing of respecting people's privacy and then allowing people knowledge, and there's a big thrust for transparency and obviously to improve what people know about in court. So this is my little contribution. Anyway, enough of the waffle. Let's talk about costs in children cases. So a bit like when I was talking about cost in finances cases on Sunday, the start point is Senior Courts Act. It used to be called the Supreme Court Act. Senior Courts Act 1981, Section 51, and its costs are in the discretion of the court. So totally discretionary. So family law having a lot of discretion in it. If you get to the end or get to a time when you're applying for costs, first thing you need to know, the judge, the magistrates, they have discretion. So how is it going to be exercised? You then look at the family procedure rules. It's again same rule 28, and that says the court may at any time make such order as to costs as it thinks just. So unsurprisingly, perhaps the court makes an order that it thinks just, and at any time, so it could be any stage of proceedings. And interestingly, quite geekily maybe, if there was nothing in the order in an earlier hearing and later on you can actually apply retrospectively and say, should have made this order at that time. It's a bit unusual if you do that. Usually judges expect you to raise your costs applications at the time. So the court may at any time make such order as to costs as it thinks just. Then you're going to then look at applying the overriding objective. The overriding objective is a list of factors that part 1 of the rules, also applies in civil proceedings. And the overriding objective is broadly doing justice between the parties, having regard to the welfare of any child and the circumstances of the case, and broadly the overriding objective. You're also going to be looking in this area at the civil procedure rules, rule 44, and there's an interplay. I have no idea why they just can't put all of the rules about costs in family proceedings just in the family procedure rules. I kind of strongly object to the fact that you're just going here and there. So I'm just going to put that out there. It's disorganised. I just don't think it's helpful. You go to the family procedure rules, Rule 28 and Practice Direction 28, and then there's also factors in the civil procedure rules, Rule 44. So that's where you're going to find this stuff. And in the civil procedure rules, when you go there, remember it's not the family procedure rules, the civil procedure rules. It says that the general rule in children cases, that if I can summarise it, it doesn't say exactly this, you have to read it through. The general rule is that a party is not entitled to their costs. The general rule, okay? That's not a presumption, it's the general rule. Which, when you think about it, is understandable because there's all sorts of arguments for not making costs orders in a children case. One that used to be made all of the time was, well, it's just going to make things worse, isn't it? In general terms, it's going to make, increase the difficulty and the bitterness, and, they're both parties in private proceedings or in care proceedings. Everyone's put their case, and the court is conducting an exercise trying to get to the outcome which is in the best interest of the child. So if you're going to pile in a costs order or the threat of a costs order, that's not generally going to help. So that is the general rule. Okay, that's not the end of the story though. And just to add into this, that whether it's public law, i.e. care proceedings, or whether it's private children law, it's the same regime, the same arguments, the same case law. So that's quite handy, something simple there. Whether you're in public proceedings, whether you're in private children proceedings, you're going to be looking at the same cases, you're going to be looking at the same arguments and the same rules about it. So what I'm saying applies across the board here. There's been a couple of cases that have discussed this, and there's some key words that's really, really important to bear in mind. These cases were decided in the Supreme Court, so the top court, and they go back from first one 2012, the other one 2015, so well-established principles. Now, of course, there's always lots of case law you can look up, but what these cases essentially say is there's two big areas. Costs will likely be awarded if there has been either reprehensible behaviour or an unreasonable stance, and then that gets a gloss on it, beyond what is, an unreasonable, significantly unreasonable. So you're looking at two areas. Has there been reprehensible conduct in some way, or has there been you're going significantly beyond what is reasonable? But don't forget that in a children case, there's more than one reasonable. The one party might be arguing one thing, someone completely different, and they're both reasonable arguments. So it has to go beyond what's reasonable. Okay, so we're going to dive in and have a look at what that might mean. So that's how it was explained. And then a later case actually said, well, look, it could be more than that. It's not a static rule. It's any circumstances where it is just. So it's not set. But I think if you have those arguments or you're resisting them, if you can remember those kind of phrases, that one party had behaved reprehensibly. So you might be quite a bit of litigation. These two main cases were against a local authority where, as you can imagine being in care proceedings as a parent, and the local authority had behaved in ways where they hadn't got reports in, or they'd not presented the case in an even-handed way. It's really important that the local authority were trying to say that a child should be removed from its natural parent, or the carer or parent. It's very important that you get things right, and in some of these cases they just haven't. And so the sort of things that you might be arguing, say you were a parent, and that, let's say in day 13 of a care case, and let's say you were a grandparent that had, one of the cases was a grandparent care who'd done all the right things and had incurred significant costs. They hadn't got public funding, that's particular circumstances. And so if things had gone wrong, like lots of adjournments and increasing the costs, those are the sort of case where you could say it's been reprehensible conduct, or you might say there never was any basis, let's say, in a different circumstance for bringing these proceedings. So you might then say that's a significantly unreasonable stance. And these are the sort of things that you're looking at. So, and the broad tagline would be whether it is just in all the circumstances to make an order for costs. So it's not, if you win the case, I'm going to apply for costs. It saw something I was doing. If you don't agree about this, we're going straight to court and we are going to get our costs against you. And I thought that was just completely unreasonable, because there were two parents. One had one view about something, one had a different view. And so, at the drop of a hat, it was a solicitor's letter, we're going straight into court. Hadn't even really discussed an issue about parental responsibility. And so, it's worth remembering, if you get that kind of letter, are you being unreasonable just to want your voice heard and to have a view, and to suggest that, where there's going to be a costs order, the first ever letter that's sent seems to me quite remarkable. So do think, have I behaved reprehensibly? Have I been significantly unreasonable? If you haven't, what are they talking about? So it really is worth knowing how the courts would look at it. The court can make an order at any stage of proceedings. So one area that might spring to mind where a party might say, I would like an order for costs, might be, let's say there's a fact finding, and let's say that all of the facts are found. There's 5 allegations, and one party, they're both paying privately. Let's imagine this situation. All of the facts are found, and legitimately a party could argue, you knew the truth, we've gone through this is a ring-fenced area of the case, you should pay the costs of this. And there's certainly a reported case on that. It's not saying that I've won, you pay the cost. It's saying, we were just talking about facts here, you knew the facts, you could have admitted this, you decided not to, there's been significant costs, I want my costs, and that would found that application. Or it could be the other way around, couldn't it? It could be 15 allegations, or whole history, none of which is remotely true, and the courts dismissed the whole lot, found them completely untrue. You might then want to say, I have been put to these significant costs, and you can argue that and say it was unreasonable. You knew that these were completely untrue, these allegations. What's important to remember, the court's always looking at, family cases have a partly inquisitorial and partly adversarial aspect. And just to say, I'm going to be doing a talk, someone raised, could I do a talk about what happens in final hearings? I'm going to be doing a talk about that in maybe next week. So the court's always looking what's in the best interest of the child, and so try to found your arguments or your resistance to them on, well, this isn't in the welfare of the child because X, Y, Z. And so in the cost arguments as well, you want to be founding your arguments there. This party has behaved reprehensibly. That party is extremely wealthy. I have, very little funds. I am looking after the child. They could have either agreed all these facts or not agreed, and whatever the outcome was. And you can have your arguments as to costs. It's probably more difficult to get costs when it's a welfare hearing, because there could be genuine arguments on either side, though there could be very different outcomes. And because, for example, the court's made an outcome, the child is to live with one party, and they were both giving their reasons why the child should live with one party or the other, doesn't mean to say the person has, in quotes, lost or is wrong, and so it's unlikely there will be any costs orders. It's more likely to be about The court has ordered a particular thing to be done at a time. Oh, let's just imagine someone just didn't turn up for a hearing. I had one and we got a costs order where I was acting for the mother and the father. I can't remember the facts, and it's good I can't, because I'll fudge them a bit. I don't want to identify anyone. But it was essentially, we'd served the bundle, I think, and then he didn't come to court. He'd resisted everything. We'd made very reasonable proposals. I think it was leaving the jurisdiction, something like that. Resisted it all the way. And it meant that we all went to court. He didn't come to court and sent some kind of message and said he hadn't got the bundle or whatever. Way we did it, we sent... we have emails that are recorded emails, so we could show recorded email. We could show he'd opened it. We could show that it really, really was. It probably was completely nonsense what he was saying. But anyway, the judge gave him another chance, and he got relisted again. And then I don't think he turned up then. And we had to go through the whole thing. Hello. All he had to do, if he was going to agree, he just needed to agree not turn up twice and all those extra costs. Of course, we got a costs order, and rightly so, as far as I'm concerned. That was complete waste of. All he had to say was, yes, I'll agree this, and that's a sort of thing. I think it's completely legitimate to pursue your costs order. In terms of other things, let's think. Fascinating to me when I was looking at it. I found one case that I'm just itching to look at, where, and it was a case in which the court was saying, look, there's a difference in one of the issues you can raise. If one party is much more wealthy than the other party, then you can say that is a factor. So this lady she'd gone to prison at some stage, didn't come to the final hearing. The other side then got a costs order against her. And then it was pointed out that she'd sent someone to represent her, and that person's fee was £1,500. And on the other side, they had a QC, and his fee was £25,000 plus a junior at £12,500, and I think they got a costs order for the payment, and they obviously knew this woman, I don't know, wasn't going to turn up, and spent all of that money on a short hearing. And I think the court just said completely and utterly disproportionate to have spent that money. But I want to find out who that brave person was that went to court against and argued the case with that brief fee, when there was such a disconnect between the representation, the cost of it on each side. So that's another thing to talk about, proportionality. So if there is a costs order and you, let's say there's a costs order against you, then you can argue that the costs are too high, they're disproportionate to the issues, in terms of all the things I talked about in finances, in terms of how you get the costs order. If you're applying for a costs order, you would put in your cost schedule. It's good practice to put it in a day in advance. You should do that, you should serve it. The court can then make a summary assessment of your cost by going through that, or it can make a detailed assessment and put it off, and then a judge looks at it in more detail, and you it's dealt with in a different process. That's more complex cases. So in terms of then the getting a costs order in a children case, big takeaway is, yes, you can get it. You should look for reprehensible conduct. You should look for unreasonable behaviour out of the bounds of the what would normally be reasonable, and the sort of instances where a party has had a loss and it has been caused by that kind of conduct. And it's really worth remembering that the court has powers to order a proportion of costs. It might say 50%, or it has the power to order them from a set date to a set date or after a particular time. And as I've already said, it can be for part of the proceedings and not all of them. So there's all of that flexibility there. You know, with discretion comes that flexibility. And what I would say you should think about is the costs. The court's always having that, looking at, you know, what's overall in the interest of the child. So there could be a situation, and it's not impossible, that a party had lost the case and still could make a claim for a cost order. I was thinking about it's quite an interesting concept. It really isn't cost follow the event. There might be a party with much more by the way of assets, and overall the cost order should be in favour of the party that didn't have them. It would be in the welfare of the child. So it's really quite an interesting area. And I think there's all too often people just thinking you can never get a cost order in a child case. That's it. It's never going to happen. But it's always worth thinking through, are there aspects of this where a party has behaved reprehensibly, they've fuelled litigation, and I don't think it should just be accepted that, it's fine whatever you do in a children case, because it's not fine. It's not fine in lots of ways. If it's a serious matter, isn't it, to be in litigation, and there should be a good reason for it. And so there should always be this analysis: is a party behaving in a completely unreasonable way in terms of their conduct and the way they're doing things. There's loads more probably. If anyone's got any particular questions, you can always directly message us. We're trying to just, give you a bit of ownership and understanding. These are complex areas. If you have the thoughts that, I think there's cost issues here. If you can't get a lawyer to do it, certainly do as much research as you can if you're faced with the cost claim in the same way. And remember, and I think it's for another day because there's only so much I can cover, where you can ask in certain cases for the other side to pay your costs so that you can litigate. So that's another area which I find quite interesting, and the hoops you have to jump through to say, I can't afford this, he or she can, I'd like them to pay my costs so that I can have a lawyer, and that helps the court. So thank you so much for listening. Very grateful. Good to see you. And I think the next one I'm having a chat with somebody, can't remember who, but you can always send in ideas of things you want me to cover, and I'll do my best. Thanks very much. Have a lovely week. Bye.